Chairman Shanley.
Present.
First Vice Chair Messier.
Present.
Second Vice Chair Corvasi. Representative Ackerman.
Here.
Representative Agello.
Here.
Representative Baginski.
Present.
Representative Felix. Representative Hall.
Present.
Representative Kennedy. Representative Knight.
Present.
Representative McGaw.
Here.
Representative Nardone. Was that a present? Representative Newberry.
Here.
Representative Shawcross-Smith.
Present.
Representative Tansey.
Present.
Chairman, we have a quorum.
Thank you. We have 12 bills on today's calendar. I'll entertain a motion to hold all 12 of those bills for further study. Moved by Deputy Whip Ackerman. Do I have a second? Second by First Vice Chair Messier. Madam Clerk, can we have a roll call vote, please?
Chair Shanley.
Yes.
First Vice Chair Messier.
Yes.
Second Vice Chair Corvasi. Representative Ackerman.
Yes.
Representative Agello.
Yes.
Representative Baginski.
Yes.
Representative Felix. Representative Hall.
Yes.
Representative Kennedy. Representative Knight.
Yes.
Representative McGaw.
Yes.
Representative Nardone.
Yes.
Representative Newberry.
Yes.
Representative Shawcross-Smith.
Yes.
Representative Tansey.
Yes.
The ayes have it.
Thank you. Today we have kind of a diverse calendar. We're going to begin by looking at the legislation relating to medical marijuana, then move on to the legislation that addresses reapportionment. So if you're hanging around for one or the other, this is your notice as to when in the hearing you might expect to see the bill you're interested in addressed. The first bill we're going to look at comes from Chairwoman Serpa. It is House Bill 5190. Chairwoman Serpa's calling in to introduce her bill. It would include domestic pets as eligible to use medical marijuana if certified by a licensed veterinarian. Do we have Representative Serpa available? Good afternoon, Chairwoman.
Good afternoon, Chairman. I'm on, and can you hear me now?
We can definitely hear you now. Thank you and welcome.
Okay. Thank you, Chairman. Thank you for hearing me early in the day, too. I appreciate it, and members of the committee. This bill, 5190, is essentially an extension of the Thomas C. Slater Medical Marijuana Act that we passed several years ago that extends medical marijuana to human beings who suffer such conditions as MS, glaucoma, other debilitating conditions that we're all familiar with, and it extends that right to pets. And I have said that some people may scoff at this bill, but those of us who have pets or who have had pets know that many of us think of them as members of our extended family, and we'll go to great lengths to provide them comfort and well-being, either for a chronic condition or for an end-of-life condition. So this would allow their owners, the pet owners, to become authorized purchasers of medical marijuana, and they would be able to administer it to their pets. And that's essentially what it is. It's enabling legislation for veterinarians who want to participate in this program. We're not forcing any veterinarian to participate. And DBR would set the rules and regulations for the vets, just as they do for any other caregiver or medical marijuana center. And as I said, it's not a legislation that requires vets to participate, but they can if they wish to. And that's essentially it, Chairman. That's the bill.
Thank you, Chairman. Any questions for Representative Serpa from members of the committee? No questions. Thank you very much, Rep.
Thank you, Jim.
The first witness we have signed up is Dr. Ralph Pratt. Is Dr. Pratt available? Good afternoon, Dr. Pratt. We're here discussing Chairwoman Serpa's bill, House Bill 5190. You have the floor to testify. Please try to limit your testimony to 3 minutes or less. Welcome.
Okay, thank you. My name's Dr. Ralph Pratt. I serve on the board of directors for the Rhode Island Veterinary Medical Association, and I have over 30 years of small animal clinical practice. To the Rhode Island VMA membership and the association, this bill and the companion Senate bill come as a complete surprise. You've probably seen our written testimony that indicates that medical marijuana products, at least most of them, are considered toxic and have no clinical indications for pets. And so although veterinary supervision is specified in the bill, we know that a substance generally considered safe in humans, as these substances are, will be given to a pet, often without veterinary supervision if the people have it available. Classic example would be acetaminophen in cats, and it's not because cats are smaller, it's because most of our pets metabolize drugs far differently from humans. Dogs and cats are not just small humans. Acetaminophen in cats, people often give it because they feel that it's safe, but it leads to multiple organ failure and slow, painful death. So I feel this bill will, by making people feel that medical marijuana is okay to give to pets, people will have it available and will go ahead and give it, rather than relieving animal suffering. This is likely to cause increased animal suffering because, again, we have no clinical indication to use the product. Thank you.
Doctor, do you have any medical evidence as to what harmful side effects might be for administering medical marijuana to pets?
Right. Well, we see toxic exposures with just accidental exposure to very small amounts of recreational pot product, most commonly. We see stumbling and coordination, agitation are common, but with larger doses, especially the stronger medical products, coma, seizures, and death are possible.
Thank you. Any questions from members of the committee for Dr. Pratt? Representative McGaugh?
Thank you. Just curious about if there is any literature out there to support the use of this product in pets.
No, there's no medical literature supporting the use because of the toxic side effects that we see. There is clinical indications for CBD products, but not THC containing products.
Thank you.
Any further questions for Dr. Pratt from members of the committee? Seeing none, thank you, Dr. Pratt. Next witness we have signed up is Stephen Alves. Good afternoon, Mr. Alves. We're here discussing House Bill 5190, and you have the floor. Welcome.
Welcome. Thank you, Mr. Chairman, members of the committee. I'm here representing Lila's Love, Susan Richardson, who is the impetus for this bill, and she will be testifying, I believe, maybe next to really explain the bill and the reasons behind it. I just wanted to just mention one thing, that this bill is just enabling legislation. None of this can happen without a veterinary prescription. So I'm just here if anybody has any questions or anything else. But Susan Richardson, who will be on, will explain the bill and her research and her background. She has a long history in veterinary medicine. So with that, thank you for your time.
Mr. Alves, one thing I wanted to point out to you on page 4, in terms of paragraph or line 21, a qualifying patient definition defines a domestic pet that is a resident of Rhode Island. It make more sense to have the owner of the pet be a resident of Rhode Island as opposed to,
Right.
I'm not sure how we would prove residency for a dog. That's a whole nother issue.
Okay, I'm sorry. Yep.
Just might be something to fix up if the legislation were to pass.
Serpa, who's been gracious enough to sponsor this bill, and talk to her about coming up with an amendment.
Excellent. Any questions for Mr. Alves from members of the committee? No questions. Thank you very much.
All right, thank you.
Next witness we have signed up is Susan Richardson. Good afternoon, Ms. Richardson. This is the House Committee on State Government and Elections. We're here discussing Rep. Serpa's bill, and you have the floor. Please try to limit your testimony to 3 minutes or less. Thank you and welcome.
Okay. Hello, Representatives. I'm so happy to have the opportunity to speak to you all today in support of Bill number 5190, legalizing medical marijuana for animals via prescription. I would like to extend a special thank you to Chairman Shanley and Representative Serpa as well for sponsoring this vitally important legislation. This bill is very important to me personally as I had a big part in its creation. I received my bachelor's degree in biochemistry from St. Joseph's University in 1996 and went to work at Pfizer doing drug research and drug safety evaluation for investigational drugs in phase 2 of drug discovery. I worked with rodents, dogs, and primates by performing acute, exploratory, escalation, toleration, and chronic studies. It was there I gained experience in drug preparation, dose determination, and clinical chemistry and drug metabolism analysis under strict FDA guidelines. While I valued my experience there, I left and started my own animal care business. I realized there is a need to help animals with special needs and health ailments in new ways that aren't currently possible. At the same time, in 2011, I became a Rhode Island medical marijuana patient and quickly discovered benefits to my personal health far beyond what my doctor or I expected. This inspired me to research medical cannabis, eventually working for Greenleaf Compassion Care Center and learning about the industry firsthand. My job duties included formulating concentrations, calculating dosages, and baking edibles, and learning about the different therapeutic applications of cannabis. The Rhode Island medical marijuana program is heavily regulated by the state. All medical cannabis is subject to rigorous testing by analytical laboratories, which are accredited and approved by the Director of the Rhode Island Department of Health. Some variables of this testing include testing for residual solvents, cannabinoid potency, microbiologicals, water activity, pesticides and growth regulators, as well as heavy metal. The Rhode Island Department of Business Regulations also requires manufacturing and labeling of cannabis products to adhere to very strict standards. It was clear to me that this medicine is extremely high quality and tested rigorously and conformed with industry standards. Current laws on the federal, state, and DEA regulations for professionals restricts veterinarian professionals from discussing or prescribing marijuana products for pets. Hesitation on the part of veterinarians in Rhode Island to discuss the benefits of medical-grade marijuana is mostly founded in lack of familiarity of how it works and the legal landscape surrounding it. All of this is changing, however. Veterinarians are becoming more educated on the topic and are increasingly enthusiastic about how we can improve the quantity and quality of life with this incredible medicine. This legislation is intended to give veterinarians the ability or option to make medical marijuana accessible by prescription if it is in the best interest of an animal. It can provide an infrastructure that has never been available and could become a hub of research if it evolves, so we can support and integrate more research into this model. This should be the right of every pet owner and will help eliminate instances of owners taking it upon themselves to administer medical marijuana to their sick and dying pets without the proper knowledge or skill, leading them into potentially dangerous outcomes. We need to articulate publicly what we already know privately. All Rhode Islanders will benefit from this progressive legislation, and our great state will continue its long history of compassionate legislation and personal freedoms. Thank you for your time.
Thank you. Any questions from members of the committee for Ms. Richardson? No questions. Thank you again for your testimony.
Thank you very much.
Next witness we have is Judy Mclennan. Oh, Lenny Lopes is available.
There you go.
Good afternoon, Mr. Lopes. How are you?
Yes, I'm doing well, Chairman. How are you? Good afternoon, and members of the committee. Let me know when you want me just to say my piece.
You say your piece, Mr. Lopes.
Wonderful. On behalf of the Rhode Island Veterinary Medical Association, I understand that Dr. Pratt may have given you an overview of the remarks. I just want to let you know we have a letter on file. And just by way of quickly, I represented in the past a medical marijuana entity, and I sought to have a qualifying condition added to the medical marijuana list. And it took a few years to have it happen because we needed the medical data and the test to prove the level of medical efficacy on the product. So with that, I would like to say that at this point in time, we simply have to oppose this measure because there is simply not enough medical evidence to prove that the way the substance is taken in by a particular species or animals other than humans at this point in time, we don't know whether it helps or not. I know there's some preliminary studies on CBD oils, and they seem to be, I don't want to say promising, I don't overstate it, but clearly there's a lot more work that needs to be done. And with that, Mr. Chairman, I say respectfully, because Rep. Serp is one of my favorite people up there, I just hate to oppose her bill, but at this point in time, there simply is not enough medical evidence to prove or show that there is any way that the substance sought in this bill is good for animals. So with that, I close my testimony.
Thank you. Any questions for Mr. Lopes from members of the committee? Thank you very much. Lenny, I noticed you're signed up on a couple other bills. Were there any other bills that you wanted to speak to while we have you on the phone?
At this point, like I said, I'm not in my office, Chairman, and I apologize. So at this point, I think I'm all set.
Okay. Thank you. Have a great afternoon.
Thank you.
Do we have Judy Mclennan available now? Good afternoon, Ms. Mcclendon. We're here discussing House Bill 5190. You have the floor to testify. Please limit your testimony to 3 minutes or less. Welcome.
Thank you very much. Good afternoon. My name is Judy Mclennan of Portsmouth, Rhode Island. Thank you for letting me testify. I am the caregiver of 3 Labradors. I'm speaking in support of Rhode Island House Bill 5190. Thank you, Chairman Shanley and Representative Serpa, for sponsoring this legislation, which expands the existing Edward O. Hawkins and Thomas C. Slater Medical Marijuana Act to include, and I quote, any animal having debilitating medical condition as determined by a veterinarian for purposes of a prescription for medical marijuana, end of quote. Ladies and gentlemen, please tell me why should medical marijuana only be for humans? Research has shown that sick animals can benefit from medical marijuana in the same way as humans. Positive anecdotal evidence is rampant, but animal owners and researchers are hesitant to share their beautiful stories of healing due to the fear of incriminating themselves, as they are afraid of possible criminal penalties, seizure of their animals, or jail time. Restrictive laws make these human heroes afraid to speak out. The Rhode Island medical marijuana program is laboriously regulated since 2006. The Department of Business Regulations, as well as the Department of Health, for people suffering from chronic or debilitating medical conditions such as cancer, glaucoma, seizures, chronic pain, post-traumatic stress disorder, digestive issues. And these are all under medical supervision of a licensed physician. Industrial hemp-based CBD is newly regulated since 2018 as an agricultural product and does not hold the same medicinal value as medical-grade CBD, which has been heavily researched over the past 15 to 20 years. I have little confidence in hemp-based CBD because it can be bought online from other states as well as any type of store. The existence of these hemp CBD shops can be misleading and confusing, and our patients are paying the price. On the other hand, medical marijuana guidelines do not leave any room for such uncertainty. Therefore, the reason I'm testifying today is I have more trust in this legislation that supports the use of medical marijuana for our pets through the use of prescription by a licensed veterinarian. I am sure that many people listening to this testimony today have animals. Don't all of us who are animal caregivers want only the best available care for those animals who are our family members? It is only fair and just to extend the compassion we show to humans to the other members of our family, namely our animals. I urge the House with all of my heart to seriously consider passing House Bill 5190. Thank you so much for your time.
Thank you, Ms. Mcclennan. Any questions from members of the committee?
I do not have any. Do they have any of me?
No questions on either direction. Thank you. That will
Okay,
conclude
thanks very much.
testimony on House Bill 5190. Next, we have the pleasure of Representative Slater's company. He has a couple of bills on our calendar, House Bill 5021 and House Bill 5017. Whatever you'd like to start with, Representative Slater, welcome. And good night.
Can you hear me now? Oh,
Excellent.
thank you, Chairman. So I was going to start off with Bill number 5017, which changes, adds the term manufacturing to cannabis. So I introduced 5017 to bring our existing medical cannabis law up to date. Some of you may not know, but our medical cannabis facilities like compassion centers, and I don't think they're included in this, but also the cultivation centers are not only involved in cultivation and sale of medical cannabis, but they also manufacture products that are used for patients. The manufacturing process at the centers includes taking the raw plant material that is grown in-house by licensed cultivation and preparing the plant material for an array of products including tinctures, capsules, topicals, and concentrates. The manufacturing process includes extracting oils from the cannabis plants using complex manufacturing equipment and techniques. Manufacturing also includes the infusion of extracted oil into ingestible forms of medicine in product kitchens and labs in these locations. The manufacturing process also extends to labor-intensive packaging, labeling, storage of products, all in compliance with the state law and regulation. The bill updates the definitions in our medical cannabis law to reflect these types of activities taking place in these facilities. When the original medical cannabis law passed in 2006 and the Compassion Center Amendment was passed in 2009, no one envisioned the technical nature and advances in product manufacturing and making medical cannabis products. The bill outlines a definition for manufacturing the statute to adequately reflect what is happening now in the medical cannabis facilities. So the reason for this clarification is depending on where you are in the town, as we know, we have the tangible taxes that many businesses have to fill out the forms, and manufacturing equipment, when you're considered manufacturing, is treated differently. If you're not considered manufacturing, they can tax you a lot more on that equipment that they go in and see. So that's part of the reason. I have someone that's more in tune with that, a lawyer that deals with these issues that is in tune with that version of it. Some folks, just to clarify, I've received some calls from cultivation centers and others. This by no means is meant to be some sort of Trojan horse to allow the new. There's a process going on right now to add 6 more compassion centers, and this is by no way to allow them unlimited grow or anything like that. This is mainly just to address the tangible tax issue that can be treated differently from town to town. So,
any questions from members of the committee for Representative Slater on 5017? No questions.
Do you want me to introduce, or do you want to take the, I think there's a witness on this bill.
There's one witness. It's up to you.
You can take the witness that way there.
Okay, we can see we have a Sanford Resnick signed up.
Yeah.
Good afternoon, Mr. Resnick. We're here discussing House Bill 5017. You are signed up in support, and you have the floor.
Thank you. Good afternoon. I appreciate the opportunity to testify in this bill. This is actually about classification and standardization of a process, a manufacturing process, which is the transforming of a raw material into a finished product. For example, and I like to use the example of taking a cotton seed, going through a manufacturing process, and end up with a t-shirt or a kernel of corn going through a process and turning out oil, or plant-based medicine, which starts as medicine, starts the plant and turns into medicine. And so we look at this as a manufacturing process. I have worked with various ordinances throughout the country with them, read them, did work on them in states like California, Colorado, Massachusetts, in Delaware, Maryland, down to Florida, which all refer to this process as a manufacturing process. Now, why is this important? Because we've been struggling. The courts in Rhode Island all over the country have been struggling. What is this? Is this an agricultural use? Is this a manufacturing use? Is it a business use? We have 39 cities and towns in Rhode Island, 39 different zoning ordinances, some of which have no legislation in regards to this, some of which recognize it as agriculture. Some of them have given permission. The city of Warwick, for example, has no ordinance, but looks at the use as a light industrial use. There are others that classify it differently, and I think we need some classification so that the cities and towns and the courts have the basis to make a decision as to whether or not they want this type of use in their town, where they would want it, but at least everybody now looking at a state definition. So we all understand what we're dealing with. So I've worked with a national consulting company, and we've had them take a look at our process, a process from the beginning of the seedling to the finished product. And they've taken a look at this and described this as a fully integrated manufacturing process. And they've also introduced me to what initials didn't mean much to me before. It's ASTM International, and that would be familiar to those who know that the masks that we're all wearing now have ASTM standards. So there are international standards for all products, and there is a committee going on now, which is actually ASTM D37, which is studying the process. And they are trying to do the same thing. They're trying to classify and standardize an industry which we all know is a growing industry, and we're trying to get it standardized within the country, probably as we go on in the world. So what's the real benefit of this? Well, the benefit is that we get technology, which is standard, we get safety, which is standard, we get efficiency throughout the world. So at the end of the day, we'll have a lot better industry just because of these simple little tweaks we have to do. An industry which is growing by leaps and bounds throughout the country and throughout the state of Rhode Island. So I would ask that you pass this bill, which will now start the standardization in the classification of the manufacturing of marijuana.
Thank you very much. Any questions from members of the committee for Mr. Resnick? Thank you for your testimony. That concludes testimony in House Bill 5017. Next, we will move to Representative Slater's other bill, House Bill 5021.
Thank you, Chairman. I've put in 50221 the past few years. It was clear in the original intention of the legislation that we had passed for medical cannabis that there was clear language in there to prevent discrimination against medical patients from employment. This bill actually comes. I worked with the ACLU on this language in this bill to clarify the original statute. Which would clarify the protections for the medical cannabis patients against discrimination by employers based on the patient's status of marijuana users. The current statute explicitly bars discrimination against medical cannabis cardholders in a variety of contexts, including employment. And despite the law's seemingly clear language, some employers have taken the position that denying employment to a medical cannabis user for failing a drug test because they have cannabis in their system does not discriminate against them on the basis of their status as a participant in the program. So this stems to, there was a case already, there's case law maybe a year or two ago, handled by the ACLU. It was Callaghan versus Darlington Plastics, and the Superior Court judge rejected that strained interpretation of the law, which, if accepted, would have undermined the whole point of the statute's anti-discrimination protection. This bill would codify the clarification of the law that there is no confusion about the protections for patients who are lawfully using marijuana in medical purposes and who are not taking it on the job or working in an impaired capacity.
Thank you. Any questions for Representative Slater? Representative Newberry.
Thank you. Scott, I just have a quick question.
Yeah.
I haven't read the old legislation. I'm looking at it now, so maybe you know the answer off the top of your head, or maybe, but I know pilots, for example, have very strict rules about alcohol, drugs, things like that, designed to protect the public. So I understand that this says they're not on the work site impaired, but I know pilots' regulations, I noticed my daughter was one, go well beyond that. I think that's not necessarily a bad thing. Are there any exceptions for certain professions where you really want to make sure someone is not impaired, even if they aren't, you know what I'm saying?
Yeah, so I think those are already in place, the protections for pilots, and also this doesn't take away, like if you're a CDL, they can randomly drug test you, and you can't really use cannabis, I don't think, in those professions, you know?
That's what I'm getting, yeah, that's what I'm getting at. Thank you.
This is just really, this came out of, there was a young woman that applied for a position at this place, and she was a medical patient. She applied for an internship, and they drug tested her, and they refused to give it to her, the position. They approved her for the position, and then when this went before the courts, they had said that they said that it was clear what the law originally intended, that you can't use someone's status as a patient. Now, if someone's showing up as an employee, that whether they be using oxycodone or some other prescription drug that they're not supposed to be using, or operating heavy equipment, or working under a condition impaired, then that's still the employer's right to pull them out and not have them in that capacity, you know?
Okay, no, thank you. I just wanted to make sure, I agree with the concept of this. I
Yeah.
just want to make sure we don't create an exemption we don't intend to for certain
No,
professions.
I think this will just clarify the original law and make it clearer for employers, so, thank you.
Any further questions from members of the committee? Representative Knight.
Rep. Slater, I don't have any questions. I just want to take this opportunity to say this is I think a much-needed amendment to this law, and I really appreciate you bringing it. I'm 100% in favor of it. I was just having this conversation the other day with a neighbor who works in the company who we were talking about medical marijuana, but the policy, it's a drug-free company and they do it with tests. And what do you do with the person who's got 2-week-old metabolites or whatever they are, cannabinoids in their blood? It's unfair to the class of people who we have said can use this medicine under a doctor's supervision. So I think this is a much-needed fix in the face of a rather obstinate sort of HR stance in the business world, and I appreciate it.
Any further questions for Rep. Slater? Okay, next we'll move to the witness list. Jared Moffett is the first witness signed up. Good afternoon, Mr. Moffett. We're here discussing House Bill 5021. You have the floor to testify. Please limit your testimony to 3 minutes. Thank you.
Great. I'm with the Marijuana Policy Project, and I want to thank the members of the committee for allowing me to speak on this bill today. And I want to thank Representative Slater for submitting this bill. I think it's a very obvious and needed clarification. Medical cannabis patients, and so I just want to express that I think this is an obvious and needed sort of rule and policy that's already intended by the legislation, and I think this just clarifies it. So I'm grateful to also the ACLU for working on this issue, and with that I'll just conclude my comments there.
Thank you. Any questions for Mr. Moffett from members of the committee? No questions. Next witness we have signed up is Ellis Waldman. Good afternoon, Mr. Waldman. We're here discussing House Bill 5021. Please limit your testimony to 3 minutes, and please proceed with your testimony.
Thank you very much, and thanks to all of you, ladies and gentlemen, for giving me the opportunity to speak. My company is Walco, often called Walco Electric. We have 2 locations here, one in Providence and one in Pawtucket, and we employ 80 some odd people. We have been a Rhode Island company since 1931. So let me first begin by saying that as a realist, I'm not opposed to recreational marijuana, which I believe is just going to happen because it's a source of revenue and it's the way society is going, and we already have medical marijuana. What I'm very concerned about are the holes in the bill as they exist today for a company like mine. My company deals with heavy equipment, with high voltage, high current, both in our facility and out of our facility. And there is no clear definition of what under the influence or impaired means, number one. There is no standard that we can test to. The second thing is that we have an obligation, and we treat that very seriously here in my company with regard to OSHA and maintaining a safe and healthy place. There is simply no way that we can possibly maintain a safe and healthy place without random testing for those people in those departments that are in safety-sensitive jobs. We pick up 5 tons, 10 tons, move them on a crane. We're dealing with high voltage and very high current, which is very serious. It's almost impossible or very difficult to know whether somebody is impaired. And after an accident, which I do not want to have to encounter, it's too late. And then the fight becomes over, were they not impaired. There must be, for the safety of the people in Rhode Island who work in companies like mine with safety-sensitive jobs, there must be random sampling, the same way we do for the federal government with our truck drivers. There must be random sampling. The sampling must be against the standard, and so that it's very, very clear and very safe. I beg of you to please pass your bill, but please include that. Otherwise, people like myself are going to be put in a very, very difficult situation.
Thank you, Mr. Waldman. Any questions from members of the committee? I see Representative Knight has a question for you, Mr. Waldman.
Okay. Yes, sir.
Mr. Waldman, thank you for your testimony and highlighting a super important issue. As a former high voltage worker, I appreciate that. What specific amendment are you looking for? What specific change to the bill do you want?
So I would say the following, and if I don't speak like an attorney, I'm clearly not one, but I would say there must be
the connection on my end kind of poor. Things are breaking up a little bit, but can you stick with it a little bit?
Yes, I will. So what I'm saying specifically is there must be some standard as to what is an acceptable level from a blood test or whatever test they take, that what is an acceptable level, like there is for the truck drivers. I don't know where that standard should come from, but there must be a defined specific level. That's number one. Number two, I'm asking or requesting that in the bill, there must be a definition of what safety critical jobs are. Other states do have a definition, they're bullets, and it's very easy to identify that. So if there is a safety sensitive job, okay, then that job must be it must be drug free. Those people, when they're hired, must be told it's drug free. And they must be randomly sampled. It's no different than what we would do with our truck drivers. In that way, at least...
I'm sorry.
Yes, sir.
Question. What do you do with someone who has like a prescription for Klonopin, right, or Ativan, which is perfectly legal and is going to show up on a drug test? You know, and if you're using it as prescribed, it's going to be in your bloodstream, but you're not going to be loopy. But it has the ability to make you loopy. What do you do for those guys? Do you say you can't be on those kind of prescription drugs for those jobs?
No, I mean, I don't think that our company, I don't know what we do to be specific, sir. I'm sorry. We hire an outside company to do the testing. I never know who's tested which way, but it's all confidential. But I'm not suggesting that somebody, if they need medical marijuana or some other drug, shouldn't have what they need from a medical point of view. I am saying that whatever the prescribed limit should be by medical people or other people, that we can't have people above that limit working. There's too much of a risk. Too much of a risk.
I appreciate that, and well, I think what we're battling against here a little bit is, for years and years and years and decades and decades and decades, marijuana was a bad actor, right? The powers that be did not like marijuana. It was part of the drug war. We can't, absolutely not, no way ever can we accept that somebody might smoke or otherwise use marijuana. And there's been a sea change. And I think that some industries, and particularly the federal government, if you have federal government contracts, have not caught up. So the easy answer has always been to say, you know, we have a zero tolerance. If you have a random blood test and it shows up something, then you're out. That's, from a risk management point of view, that's the easiest thing to do. I'm sure your lawyers and your insurance companies for your industry have said that over the years. And what I think this bill is trying to force the question a little bit is that those policies have to change. And we all know that you can smoke on a Friday night and 2 weeks later still have that stuff in your bloodstream, but be perfectly safe to engage in heavy-duty equipment operation or fly or whatever you're going to do if you do it responsibly. And so while I appreciate where you're coming from, because nobody wants an accident, definitely not, I think that this is, your testimony informs part of the conversation that I think everyone has to make some adjustments as the legal regime around marijuana changes.
Sir, may I take a minute to respond to that?
Yeah, for sure, for sure.
So I appreciate what you're saying, although let me give you a real-life example of what we've been dealing with, especially in this difficult time to find qualified people. We, as part of our business, we completely remanufacture or repair motors and other equipment under the subway systems in the entire Northeast. So therefore, we have to fall within the guidelines of the federal government, and selected departments have to be drug-free. You've alluded to that, so you understand that, I'm sure. Okay? When we interview people, we tell them this department, for these reasons, must be drug-free. We find people who say, thank you very much. I enjoy my marijuana once or twice a week, and that's the way it's going to be, and we thank them very much, and they leave. And we find other people who say, that's not going to bother me, I'm not a user, and I'm glad for the opportunity, and we haven't had a problem. So I would, from our experience, I would say that's not a problem.
And I think that, certainly we don't want to put people in a bind who are in your boat, basically get stuck between a rock and a hard place between our law and the federal law. And I think, I'm no HR professional, I think if this bill were to become law, I think you'd still be able to say we're drug-free, it is what it is. But maybe we could build something in there, like you're talking about, to say, look, if our work is required by a different sovereign, which is what you're talking about, to require this, then we could do that and potentially cover you, because we don't want, like I said, I hope I speak for the committee, but I certainly speak for myself. I think it's unfair to put people in the hard spot between two competing policies around marijuana, between the state policy and the federal policy.
And I believe you, and I don't know the committee, but I don't know you, but I believe all of you are trying to do the right thing. So the reason I wanted to speak up was to say that we're doing the right thing for these applicants or employees if they become such, because you know as well as I do that an accident can happen before you even blink your eye, and then it's all too late. And so this has been our experience, and as I say, sometimes we see a good person walk away, but one door closes and another opens, and there's somebody else, and it's worked out satisfactorily for us.
Thank you for the conversation, sir. I appreciate it.
I appreciate all of your work. Thank you very much. Thank you.
Thank you. Any further questions for Mr. Waldman from members of the committee?
I missed that. I'm sorry, sir. Were you talking to me?
No, just seeing if any other committee members had questions for you. There don't appear to be any. Second Vice Chair Corvese and Representative Kennedy, would you like your presence and votes to hold all bills for further study recorded?
If it's held for further study, it's for me.
Okay.
Same with me.
Okay. Anybody else?
So do I sign off, sir?
You are all set. Thank you for joining us. Next witness we have is Lynette Forey-Menard. Good afternoon, Lynette. We're here discussing Representative Slater's bill, House Bill 5021. Please proceed with your testimony and try to limit it to 3 minutes or less. Thank you and welcome.
Thank you, Mr. Chairman, members of the committee. My name is Lynette Forey-Menard, and I'm here on behalf of the Northern Rhode Island Chamber of Commerce. I just want to start by saying we appreciate all the work Rep. Slater has done on this issue. There clearly is a place for medical marijuana, and we understand how it can bring relief to patients suffering from various conditions, diseases. The reason that we are opposed, I couldn't hear all the testimony of the person before me, but I have a feeling it might be the same, just from a few words that I caught. The challenge we have is the significant number of employees that have federal contracts or are in the supply chain to provide services to those federal contract manufacturers and businesses. So it would be important to the Chamber that any legislation specifically allow those who are in the supply chain to be able to terminate the employees in a way consistent with federal requirements. Until such time as the federal government either legalizes marijuana or lifts the drug-free requirement, the businesses that have these contracts are stuck in the middle.
and we don't wish to see them losing the contracts and therefore losing employment in Rhode Island. With that, Mr. Chairman, that's really our objection. I'd be happy to answer any questions.
Any questions from members of the committee? No questions. Thank you very much.
Mr. Chairman, may I just interject at one point? No, I don't have a question for that particular witness, but I know I'm coming in the eighth inning over here on this particular bill, but I have just a quick clarification. So I assume the impetus of Representative Slater's bill is to prevent discrimination in hiring of individuals who have a medical marijuana card.
That is the component to it. It's hire, discharge, or otherwise discriminate against.
Thank you.
Okay, next witness we have signed up is Jordan Goyet. Mr. Goyet, welcome. You have 3 minutes to testify on House Bill 5021. Please proceed.
Thank you, Mr. Chairman, and members of the committee. I also want to thank Rep. Slater for introducing this bill and always being such a champion of the cannabis community. I think the best reason that you can have for passing this bill is that we don't discriminate against people who go home after work and have some wine with dinner or have a few beers after the shift ends and they get out of work. Obviously, legalized cannabis is becoming a growing part of our society. We're pushing towards recreational legalization. And all this bill says is that somebody cannot be discriminated against in employment just because of the presence of cannabis in a drug test. So someone that gets a notification of a drug test 2 weeks out can stop using cannabis then. As Rep. Knight noted, that can still show up in the system weeks out. So I believe also that, we don't test or discriminate against people who have prescriptions for certain drugs like painkillers or antidepressants or anti-anxiety medications, which you're not always loopy when they're stay in your system, but you're not always loopy on them. And I think there's this preconception among some of the testimony you've heard before that the cannabis community, the people are some deviant, irresponsible goofballs that use cannabis and go out and do dumb things. We're overwhelmingly not. We were overwhelmingly the people who followed all the pandemic restrictions of staying home and staying safe and social distancing. We didn't need to adjust hard to those restrictions. We shouldn't be discriminated against in our job opportunities and our chances at social mobility just because of we like to go home after work and have a few puffs of a joint or have an edible. So thank you. By no means an expert on the subject. I'd be happy to take any questions. So thank you for the time.
Any questions for Mr. Goyet? Representative Corvese.
Again, I don't have a question for Mr. Goyet, but the analogy he used, again, this is regarding people who have a medical marijuana card and ensuring their employment and not being discriminated against. This isn't anything recreational. The example he used was someone going home and having a couple of drinks. That's recreational. So I think there seems to be a little what's the word I'm looking for? A disconnect. Thank you, between what he was saying and the impetus behind this legislation. We're talking about medical marijuana. We're not talking about recreational marijuana. Am I correct?
May I respond?
Correct. Sure. Go ahead.
My point was on medical cannabis, absolutely. And the point is medical cannabis is legal in Rhode Island. Obviously, alcohol is as well. If they're both legal, they should both be treated the same. People shouldn't be discriminated against because of the status of having of using medical cannabis, it's obviously going to show up in their system on a drug test. All this bill does is says that that presence of cannabis in the drug test alone shouldn't be in shouldn't enable an employer to just terminate them outright. So if someone is very highly impaired on the job, it's going to show up in the level of THC in the drug test. So show up very clearly. And so that was my point. I was not talking about recreational.
Okay.
I know I mentioned it, but that was not my
I'm glad you cleared that up.
Yeah, sure, absolutely.
Any further questions for Mr. Goyet from members of the committee? No questions. Thank you for your testimony. Next witness we have is Stephen Brown from the ACLU. Good afternoon, Steve. We're here discussing Representative Slater's bill. Please proceed with your testimony and limit it to 3 minutes or less if possible. Thank you and welcome.
Thank you very much, Chair and members of the committee. Stephen Brown on behalf of the ACLU Rhode Island in support of H6021, and our thanks to Representative Slater for submitting and sponsoring this bill. I first want to just emphasize what Representative Slater said in his opening comments is that this is really just a clarification of the law as it has existed from the beginning. The law has prohibited discrimination in employment against individuals with medical marijuana cards. What happened, unfortunately, is that we were involved in a court case where an employer read the statute to mean that they could still fire somebody if they were found to have any marijuana metabolites in their system, even though they weren't impaired on the job and even though they were taking it for medical purposes. Their reading of the statute was that they weren't discriminating against them because they were a medical marijuana card holder, but instead because they had marijuana in their system, which of course, if you accept that argument, completely undermines the point of banning discrimination. And a court 4 years ago actually ruled that that argument didn't make any sense. And what this bill is really designed to do is just tighten that language to avoid any sort of confusion or misconception about the protection from discrimination against people who are using marijuana for medical purposes and are not impaired on the job. In answer to a number of questions and comments that have been raised, I also want to emphasize the law already, and again from the beginning, has had a variety of exemptions, including those where federal law supersedes, requires testing or drug-free workplace, and federal contractors as well. That is already an exemption in the statute, and there's nothing in Representative Slater's bill that attempts to address that. And then the final point I would just note is what Representative Knight has indicated. People can take a variety of lawful drugs. They cannot go to the workplace and be impaired for whatever reason. At the same time, you cannot discriminate against a person who is taking medicine for an illness or disability unless it actually does in fact impair the work on the job. And all that this bill is clarifying is that the same applies when it's medical marijuana. So we hope that the committee will support this bill. We think it's a modest effort to just clarify the law, and I'll be glad to answer any questions that people have.
Any questions for Steve Brown from members of the committee? No questions. Thank you, Steve.
Thank you.
Next witness we have is Christine Canine. Good afternoon, Christine. We're here discussing House Bill 5021. Please proceed with your testimony and limit it to 3 minutes. Thank you and welcome.
Thank you, honorable members of the House Committee on State Government and Elections. My name is Christine Canine. I currently serve on the board of the Rhode Island Society for Human Resource Management, or Rhode Island SHRM, and I'm also CEO of Higher Image, a background and drug screening company located here in Johnston, and we work with companies to facilitate their drug testing nationwide. Rhode Island SHRM is a volunteer organization and represents the interests of more than 500 human resource professionals throughout our state. Our members are a true cross-section of the Rhode Island economy and come from such diverse sectors as education, government, healthcare, hospitality, manufacturing, nonprofit, professional services, and many small businesses. I'm grateful for the opportunity to provide this testimony on 5021, and although Rhode Island SHRM opposes H5021, we don't oppose the use of medical marijuana, but we do oppose this additional legislation regulating medical marijuana. Number one, it makes it more difficult for employers and HR professionals to enforce workplace policies prohibiting employees from working under the influence of drugs. It's under federal and state law, employers have the legal duty to provide a healthy and safe work environment for their employees. To satisfy this legal duty, employers are required to closely monitor workplace conditions to identify and remediate potential hazards. Drug testing, in particular pre-employment or reasonable suspicion, and also post-accident testing is one of the most powerful tools that employers have to maintain that healthy work environment. And now by elevating medical marijuana cardholders to the status of a legally protected class, H5021 will limit that ability of employers and human resource professionals to use drug tests as a guide for making disciplinary decisions affecting cardholders. For an example, you have a forklift operator, and we've actually had this happen where, they go out at lunchtime, come back, and they're impaired, which there's no definition of, but we'll get to that. And then, driving erratically, trying to run over people, whatever the case may be. If that were to be, and they sent them for a drug test, and it yields a positive result for marijuana, this bill would make it unlawful for their employer to impose disciplinary action based on the employee's status as a cardholder for that positive drug result. Also, H5021 uses the phrase impaired on premises of the place of employment or during the hours of employment. But there's no definition of what that is, and it leaves it up to the employer and the HR professional to decide for themselves. Many HR professionals, they lack the professional training, and there is training out there, but there's no exact science to this. So you're really putting it on those employers to determine what impairment is without a definition. As many of you know, without definitions, it's just ripe for lawsuits with attorneys, so making it very difficult on employers. A drug test that yields marijuana components for metabolites or above a certain cutoff, there's labs have cutoffs already, so using that is an objective, measurable standard and one that could be and should be used in those instances. We also have a real concern of what the chilling effect would be on the exercise of discretion and independent judgment by employers and HR professionals, making it difficult disciplinary decisions affecting workplace safety. By creating a private right of action for medical marijuana cardholders to sue their employers for allegedly violating their rights as members of a new legally protected class, if an HR professional disciplines a medical marijuana cardholder based on good faith but mistaken belief the cardholder was impaired in the workplace or during work hours, the employer may be subject to a lawsuit. And we suspect with this law, you're going to have, many employers will err in the favor of allowing a potentially dangerous cardholder to remain on the job, even though, accidents may have occurred, rather than suffer the consequences of this potential problem. So there's no room for error there with the employers. I also noted in listening to prior testimony, I know there was a few questions that came up. There are tests out there, I think it was Rep. Knight who had asked about what happens when someone's on some pain medication and that comes positive. There are tests for safety-sensitive positions where, most employers are doing a drug test. They have a medical review officer who reviews that prescription or a medical marijuana card. But if it's a safety-sensitive position, we'll put, safety-sensitive fitness for duty recommended, physical recommended, to make sure that they are fit for duty, as you had the previous employer, Walco Electric, describe what would happen on their workplace. So there are things out there, and they are being used, and just wanted to make sure that I stated that for the record. And I'm open for any questions. Thank you.
Any questions from members of the committee? No questions. Thank you. That will conclude testimony on House Bill 5021. Next, we have Chairwoman Vella Wilkinson with us to introduce her bill, House Bill 6192. This would allow disabled veterans to apply for as many registration plates as desired for vehicles they own. Good afternoon, Chairwoman. Thank you for joining us.
Good afternoon, Chairman and Committee. Thank you very much for having me here today. And thank you for that introduction to House Bill 6192. Ladies and gentlemen, there are a couple of different license plates that veterans would potentially have on their vehicles. One would be just a standard plate that identifies that individual as a veteran, and there's another that identifies the individual as a disabled veteran. The difference between the two, aside from the fact that one is a vehicle driven by a disabled veteran, the other one isn't, is that disabled veterans plates in the state of Rhode Island are not, do not cost anything of the veteran. So he or she, if they're qualified under Section 31-6-8 and identified by the VA as being a disabled veteran, would be able to get a veteran's plate without having to pay any kind of a fee. And what that plate enables the veteran to do is to park in any handicapped spot within the state without having a placard. And it also allows the individual entrance into, I believe, state parks without a fee. Right now, what happens is the veteran is allowed to have one set of plates for one vehicle, regardless of how many vehicles he or she may own. So if you have, like so many Rhode Islanders have, a heavy-duty vehicle that they use, you know, perhaps a truck or just a station wagon or what have you. Do they even make station wagons anymore? Am I dating myself?
Are they heavy duty if they do?
If they have a utility vehicle, and then in the summer they like to drive around in something that's lighter, sportier, a Jeep, a ragtop, or what have you, they only have one set of plates that they could use that identifies them as a disabled veteran. This bill, H6122, would enable the veteran to purchase as many registrations as vehicles that he or she owns. That's the bill.
Thank you, Chairwoman. Any questions from members of the committee? No questions.
Thank you, committee. Thank you, Chairman.
There are no witnesses signed up, so that will conclude testimony on House Bill 6192. I believe Representative Morgan is here with us. She has a bill, House Bill 6099. This is an act relating to elections, registration of voters. It would tighten up the requirements for registering to vote and for applying for a mail ballot. It mandates that driver's licenses and motor vehicle identification cards for non-drivers have a marking which identifies the holder as a foreign national. Good afternoon, Representative Morgan. Welcome.
Good afternoon. Thank you for having me, Chairman, and members of the committee. My bill deals with election reform. Elections are fundamental to our democracy, representative government. We've all heard, I'm sure we've all said President Lincoln's words, of the people, by the people, and for the people. The by the people really shows up at election time, because that's when people actually choose who their representatives are going to be. If anyone cheats or if there is fraud during those elections, then it changes the result and it changes the representation that each person gets to have. We know in Rhode Island we have many, many elections that are decided by less than 100 votes. From the school committee, well, not up to president, but there's a lot. In my time in politics, I've seen elections for representative decided by 1 and 2 votes. So any kind of cheating changed those results and ultimately changed the kind of government we have. I think that's why it is so very, very important to look at the fundamentals of our voting process. And the most important thing we can do is make sure that our voting rolls are accurate. You know, just trying to figure out what the number of people on the voting rolls might be ineligible or not eligible voters. The Secretary of State has said it's somewhere around 15%. And that's a big admission on her part. 15% is a lot of people who are not eligible to vote. They could be dead. They have moved to another state. They have moved from jurisdiction to jurisdiction. They could be double registered. They could be citizens of another country. We need to make sure that our voter rolls are accurate if we are going to have any confidence in the result that we get. And the result we get really determines the kind of representation we have ultimately. So my bill really deals with that, in large part with that part of it. You have to be a U.S. citizen to vote in America. You can't be a foreign national. There's nothing pejorative about that. My mother was a foreign national for a long time. It just means that you're a citizen of another country. And if you're a citizen of another country, you can't vote here. That's of the people. You have to be an American to vote in the United States in our elections. You have to be 18 years old. You have to have a valid address in the community, one where you actually reside. You have to have no felony conviction. Actually, I'm okay with registering online, electronic registration. But what I'm not okay with is not having to supply any documents to prove who you are when you register online. So if you want to register online, go ahead. But that doesn't relieve you of the obligation to then show a photo ID that shows where you live, that shows that you really are a citizen of the United States. And that also includes a signature card. So if somebody registers online or through the DMV or whatever, there has to be a signature card that they are sent. So when they register, their board of canvassers would send a signature card to the address on file. When they get that signature card, they would be obligated to sign it and send it back with supporting documentation, whether that's a copy of their photo ID or any of the things that we have in our law already to prove somebody's identity. And only after the Board of Canvassers in their community has checked out all that stuff are they added to the rolls as official voters. It's just a way to tighten up on our voter rolls. If they are accurate, there's a lot of things we can do. We can send out mail ballots, but when they're filled with 15 to 20% ineligible voters, mail-in balloting doesn't make any sense. There's just too many opportunities for fraud to happen. I did mention about foreign nationals. I know that Providence, I believe, is handing out photo IDs to a lot of its residents. If the person getting that photo ID is not a citizen, then according to my bill, they would have their photo ID marked with an FN, standing for foreign national, and it would be barcoded on the back to prevent them from voting. I think a lot of our immigrants are under the mistaken impression that just people have said, oh no, you can vote, and they've gone ahead and registered. One of the damages of that is if they do vote and then they later ask to become citizens, they apply for citizenship, it can be blocked with our current laws. So they can not become citizens because they have voted illegally. So I think it's important for them as well as for our own voter integrity that we have their photo IDs marked with an FN for foreign national. And that just simply means they're a citizen of another country. In just relationship with that, I wasn't able to testify when the Secretary of State was here on her bill. but she had an idea for a permanent mail-in voting list, which I just think is a really dangerous idea, especially when you have 15 to 20% of the names on our voter rolls that are ineligible voters. That voter roll is permanent. It could be accessed electronically. There is no need for any voter ID along that process. And it goes to in perpetuity, which means live ballots could show up at an address and be used fraudulently. The other item that's in my bill that I think we need to address is ballot harvesting. A ballot harvester is someone who is a political operative, who is associated with a campaign, or who has a vested interest in the outcome of a campaign. And they go to anybody, but generally speaking to our elderly or disabled in congregate care settings, and they collect ballots from people. Most of the time, they are sitting with the person at the table. They could be electioneering. They can see how they're voting. There is nothing private about it. There can be an incredible amount of intimidation and manipulation of a frail and vulnerable person. We should ban ballot harvesting. It is a bad procedure. We know that people who do it can be paid up to $20 per vote that they get, which gives them a financial incentive to manipulate people even more or intimidate them even more. And as I said, in Rhode Island, we have many, many elections that are decided by less than 100 votes. And ballot harvesting could change the outcome of that election and change the by the people part of President Lincoln's second inaugural address. I just want ballot harvesting to be banned. If we don't ban it, then we still need the two witnesses, which the Secretary of State envisions getting rid of. She just wants to dump that. I'm agnostic on the notary because many times the ballot harvester becomes a notary themselves and they notarize their own ballot harvested votes. But definitely two witnesses that are not the ballot harvester themselves. And that way we can protect vulnerable people. And that's it. Those are basically the top points of what I'm doing. I want to tighten up our voter rolls. Nobody could be added to the voter roll until they had a signature card and they proved with photo ID who they were. Ballot harvesting would be banned, and any ID cards would mark if somebody is a foreign national, if they are indeed a citizen of another country. Thank you. Any questions?
Thank you. Any questions from members of the committee for Representative Morgan? No questions. I see Representative
Mr. Chairman,
Felix.
if I may?
Yep.
Thank you so much. Representative Morgan, you mentioned in regards to the bill in regards to, as you quoted, felons voting, but I'm sure you're aware in terms of the amendment that the state passed on our Constitution restoring voting rights to people with felony convictions upon release from prison. So does your bill take into consideration that amendment?
It didn't. I didn't realize, so I was gone for 2 years. I didn't realize that you guys had passed that one. So if that's already become law, then obviously felony conviction is not one of the things that they would be held accountable for.
Okay, thank you. And also in regards to the comments that were made in terms of foreign national voting and such, do you have data in terms of, in particular with Rhode Island, as to how many foreign nationals are actually voting in our elections?
I don't. Nobody actually is looking for that information. So it's really hard to collect data when nobody is trying to figure it out. But I have friends in the community, and I have been told that there are a lot of people who are foreign nationals that are being registered to vote without understanding how much it can hurt them down the road if they get the opportunity to apply for citizenship. If they have voted and voted illegally, it can prevent them from becoming citizens. And they don't know that. Somebody comes out and says, no, it's okay, you're here, you're allowed to vote. So they register. And not only does it damage our voter rolls and the accuracy and the honesty of our elections when that happens, because when you're not a citizen, you really aren't allowed to vote in American elections. But it also can, down the road, hurt those same folks who are voting illegally, who aren't eligible to vote because they are a citizen of another country. So it's kind of a double whammy. And I think we need to tighten that up. And it's an easy thing. Many other states are using it. It protects everybody.
Yeah, I just want to caution in terms of simply saying that folks are telling you that some of our community members are registering to vote when they are not, especially if we don't have data, right? We want to be very cautious in the language that we use because language is important. So if we don't have the data and it's just hearsay or she say information, that we really want to be cautious, especially in a hearing like this where people are watching, to bolster information that is not accurate in terms of people registering. A lot of our communities who are not citizen, who may be resident and such, know that they're not supposed to be voting because particularly when you get your documents is the first thing that they tell you. But you are correct that in terms of vote, if you are to vote in an election that you are not supposed to, it can hinder your ability in terms of getting your citizenship down the road. It's not 100%. I mean, there are exceptions and folks do make mistakes. But again, I just want us to caution in terms of using language that that just may be false.
Again, nobody is looking, nobody's collecting that data. I can't tell you how widespread it is, but I have heard anecdotally that it is happening. And I guess the point is, even if it's a handful of people, they shouldn't be on the rolls. We really need accurate rolls. We need them to be U.S. citizens if they're on our voter rolls. There are certain characteristics that they need to have. And, we need to start tightening it up, making those rolls accurate now. And so as people have to come back in and renew their photo IDs, we just mark them foreign national. There's nothing wrong with that.
Any further questions for Representative Morgan from members of the committee? No questions. First witness we have signed up is J. Christian Adams. Mr. Adams. Good afternoon, Mr. Adams. We're here discussing House Bill 6099. You have the floor. Please proceed with your testimony and limit it to 3 minutes. Thank you. And
thank you, Mr. Chairman, members of the committee. Thank you for the opportunity to testify today. My name is Christian Adams, President and General Counsel of the Public Interest Legal Foundation. We're a nonprofit charity devoted to promoting election integrity and best practices. We brought dozens of lawsuits around the country related to voter rolls and have studied voter rolls closely to find a variety of things that are good and sometimes things that are not so good. I'm here today to offer support for HB 6099 and particularly some provisions that will assist election administration and compliance with various federal laws. The area that we have some specific knowledge is related to Rhode Island's failure to collect personally identifying information, which is required by the Help America Vote Act. In other words, names, dates of birth, things of that nature, unique identifiers are required by federal law. And we've looked at Rhode Island voter rolls and all the voter rolls of the country and have found that Rhode Island actually leads the nation with respect to percentages of voter records without this required personal identification information. At 20%, as a matter of fact, 1 out of every 5. Arkansas and New York are not too far behind with 16 and 10%, but states like Texas, Louisiana, and West Virginia don't have any problem at all. This particular piece of legislation would aid in the collection of federally mandated information that Rhode Island is currently deficient in collecting. So HB 6099 will pay off because the voter rolls will be cleaner, more accurate, and more in compliance with federal law. So I strongly support the provisions of HB 6099 that will do that, and thank you very much for your time.
Thank you very much, Mr. Adams. Any questions of the witness? Thank you.
Thank you.
Can we have Dominic Rapini? Mr. Rapini?
Yes, sir.
You have the floor for 3 minutes. Mr. Rapini?
Yes, I'm here.
I think you want to turn your device down. Please state your name, the organization you're with, and you have 3 minutes, please.
Yes, thank you. My name is Dominic Rapini, and I want to thank Representative Pat Morgan, Chairman, the ranking members, and members of the House, State and Government and Elections Commission, and the legislators of Rhode Island for the privilege of sharing my thoughts on election integrity. As I stated, my name is Dominic Rapini. I'm the board chair of Fight Voter Fraud Incorporated. We are a nonprofit, nonpartisan organization that investigates election issues in Connecticut, and we apply our learnings and proposals to lawmakers with ideas on best practices and potential legislative solutions to improve trust in the election process. Our website is fightvoterfraud.org, where citizens can anonymously report election concerns and fraud online through our either online or through our smartphone app. This year alone, we've uncovered duplicate voters, underage voters, and even felons voting from prison in 2020, and we are just getting started. So I strongly support Bill 6099, as it includes elements that keep voting in Rhode Island secure with common sense measures such as requiring photo ID and new proposals for driver licenses that protects the members of our undocumented immigrant community. In Connecticut, Fight Voter Fraud is becoming increasingly aware of a problem that afflicts our brothers and sisters living in Connecticut without U.S. citizenship. Immigrants are voting in undetermined numbers after being registered to vote through voting drives, automatic D&C registrations, or through thoughtless political operatives. Immigrants can apply for drive-only licenses, which do not communicate citizenship status here in Connecticut. We have been introduced to undocumented citizens that have been registered to vote and who have voted in multiple elections here in Connecticut. Not understanding the gravity of their mistake, the only way they discover their error is when they apply for U.S. citizenship and their voting history shows up and invalidates their application. In other words, they ruin their chance to become lawful U.S. citizens. Bill 6099 presents an amazing solution to this problem by adding the bar-coded label FN or for foreign national to the license, easily alerting election officials that the applicant is not eligible to vote. We believe this is an elegant solution that will preserve the path to citizenship for hundreds, if not thousands, of immigrants and their families aspiring to achieve the American dream. If we can just save one immigrant or one family and preserve their right to become U.S. citizens, then this alone will make this worthwhile for the state of Rhode Island. So nationwide support for a photo ID is overwhelming for voting in person, and even with the inclusion of photo ID with absentee ballots. Many polls, including the April 6th Rasmussen poll of 1,000 likely voters, determined that 75% of respondents are in favor of photo ID for voting.
You have 30 seconds.
Guys, thank you. Hey, we need IDs to get our COVID vaccinations, to get tested, for housing, to buy a car, even to buy M-rated video games. 19 states use photo ID to verify voters on election day. This is common sense practice that instills trust in the election process. When voters trust in their elections, they turn out to vote knowing their vote will count. As Rhode Island considers the innovation of labeling driver's license with foreign national barcodes, your state can achieve the compassionate goal of ensuring that undocumented immigrants preserve the path to citizenship and join us in enjoying the American dream. Bill H6099 is a win-win for all citizens of Rhode Island. That concludes my formal testimony.
Thank you, Mr. Rapini. Are there any questions of the witness? I do have one question. Is your organization national, or are you the head of a Rhode Island-based branch of the organization?
No, I'm the board chair. We are based in Connecticut. Our scope is
mostly can make it, but we've had national involvement in the 2020 election. I'm the board chair, and our CEO, Linda Sinkowitz, will be up the fall.
Well, thank you very much. Thank you for your testimony today. Next, we have Jason Snead. Good afternoon, Mr. Snead.
Hi.
Please state your name and the organization you're with, and you have 3 minutes, please.
Thank you very much, Mr. Chairman and members of the committee. My name is Jason Snead. I'm the Executive Director of the Honest Elections Project. We are a nonpartisan, nonprofit organization dedicated to defending the right of every American to fair, secure, and accessible elections. H6099 focuses on two essential aspects of election administration: ensuring the accuracy of voter registration records and protecting absentee ballots from an abuse-prone practice known as ballot harvesting, or the collection of voted ballots by political operatives, organizations, candidates, or others with a vested interest in the outcome of an election. I would like to concentrate my verbal testimony today on the need to secure absentee ballots, particularly against ballot harvesting. This practice sees third-party individuals offer to, quote, help voters fill out or cast their mail-in ballots. Because of the nature of absentee voting, this assistance usually takes place in a voter's home, creating opportunities for ballot harvesters to engage in actions that would otherwise be banned under most state law. For example, political operatives can engage in partisan electioneering while a voter casts his or her ballot. No such behavior would be tolerated in the confines and controlled environment of a polling place. Nevertheless, it happens in ballot trafficking and harvesting operations. In fact, a 2005 bipartisan election commission, co-chaired by former President Jimmy Carter, warned that ballot harvesting exposes voters, quote, to pressure, overt and subtle, or to intimidation. Advocates of the practice argue it should be permitted as a means of helping vulnerable voters to more easily vote. Perversely, these are the voters who are often the victims of ballot harvesting schemes. Ruth Robinson, the former mayor of Martin, Kentucky, threatened residents of public housing with eviction if they didn't sign absentee ballots supporting her re-election for mayor. She also targeted disabled residents and bribed others. She was eventually convicted and given 40 months in prison. Rhode Island itself recently became the center of a ballot harvesting scandal just last year when seniors living in a Providence public housing complex were targeted by political ballot harvesters. Moreover, the unsupervised access harvesters have to voted ballots gives them the means to alter these votes, effectively disenfranchising the voters. That tactic has been used to attempt to steal elections, as we saw in North Carolina's 9th Congressional District in 2018 and in Paterson, New Jersey in 2020. In both instances, the fraud so tainted the results of an election that new elections were ultimately called for.
You have 30 seconds.
Ballot trafficking.
You have 30 seconds.
Voted ballots. Thank you. Ballot trafficking puts voted ballots in the hands of individuals with a vested interest in the outcome of an election without any controls or supervision. It allows for operatives to attempt to steal elections. It leads to the disenfranchisement of voters, and ultimately, if it is allowed to continue, will open up doors to fraud, abuse, and error in our election system. Absentee ballots must be protected if voters are going to be able to trust that their ballots are ultimately being counted and if their voice is to be heard in our election system.
Thank you.
By contrast,
Thank you for your testimony, Mr. Snead. Any questions of the witness? Thank you. Next up is Linda Sizkowitz. Nope, I screwed that up.
No, this is Linda Sinkowitz.
Sinkowitz, just like it's spelled. Thank you. Welcome to State Government and Elections. Please identify yourself, the organization, and you have 3 minutes.
Okay, thank you.
Please proceed. Hello?
Oh, yes, I'm here. I'm sorry.
Please proceed.
Yes. Yes, Chairman, ranking members, and members of the House State Government and Election Commission, thank you for giving me the opportunity to speak on proposed House Bill 6099, and express my firm support of the bill introduced by Representatives Morgan, Nardone, and Roberts. H6099 tightens up the requirements for registering to vote and applying for a mail-in ballot, and clearly distinguishes a foreign national driver's license from a U.S. citizen in regards to voting privileges. Kudos to putting election integrity in the forefront and respecting the rights of all Rhode Island voters. As the founder and CEO of Fight Voter Fraud, Inc., a 501c4 nonprofit organization based in the state of Connecticut, we firmly believe in one vote for one legal voter. In the state of Connecticut, this isn't happening. Our Secretary of State, Denise Merrill, has put too much emphasis on easy accessibility and very little security on voting, making it easy to cheat and diminishes the integrity of the voting process. Our database, maintained by the Secretary of State, Denise Merrill, is obsolete with hundreds of thousands of registered voters that passed away, moved, or never existed, which are ghost voters. We in Connecticut are the poster child of what not to do in regards to voter integrity. H6099 here in Rhode Island clearly shows that you at the legislature want to have fair elections and ensure election integrity by verifying each and every registered voter is legally able to vote. In Connecticut, we need to clean and maintain the voter rolls of people that no longer live in the state of Connecticut, of those that have passed away, and remove 200,000 plus inactive voters. We need to clean the voter rolls so we know exactly who is eligible to vote in our elections. Hopefully, Rhode Island will make this a priority, making sure that those that are registered to vote actually still qualify to vote in the state of Rhode Island. Check and make sure that those that have passed away are removed from the voter rolls, since this is election fraud fodder to those with nefarious intentions. Maintain and cross-check the Department of Motor Vehicles to make sure that anyone that complies with the federal law 1993 NVRA, the National Motor Vehicle Voter Act, which requires anyone changing their address at the Department of Motor Vehicle to have it changed on the voter registration within 10 days and make the best effort to ensure only qualified U.S. citizens are allowed to register to vote. The use of mail-in ballots should continue to have restrictions and not be abused. Drop boxes for mail-in ballots need to be monitored with cameras and other security means. Unlike here in the state of Connecticut, where we have photos of mail-in ballots sticking out of drop boxes where anyone could take the ballot. The need for security is to ensure that no one tampers with or tries to destroy ballots that have been properly deposited into the drop boxes. I especially like the wording of Bill 6099, Section 17-9(1). All registering voters shall produce, as proof of identification, a valid driver's license, state identification card with photograph, or a United States passport. I truly wish Connecticut would mirror what you here in Rhode Island have proposed. In Connecticut, you can still vote without producing any voter ID, and in New Haven, Connecticut, they're allowed to accept the postcards sent by the city of New Haven to voters that simply state which polling precinct they should vote at. Again, no security to make sure the election integrity. Voter fraud is very real. Our organization, Fight Voter Fraud, has uncovered duplicate voters in Connecticut, voting with two different voter ID numbers, yet the same person. Underage voters voting and felons registering from prison and voting absentee, and this is just scratching the surface. In conclusion, 6099 clearly shows the intent to have every legal voter be able to vote with confidence in the voting process. I urge all the legislatures to vote in favor of H6099. Thank you for the opportunity to speak, and I would be happy to answer any questions you have.
Thank you. Any questions from members of the committee for Ms. Nerona? No questions. Thank you again for your testimony. Next witness we have is Alabama Secretary of State John Merrill. John Meyer.
Meyer Nerona.
Good afternoon. Can you identify yourself, please?
Hello, can you hear me?
Yes.
Oh, okay. Good morning, Chairman and honorable members of the committee. My name is Maya Nerona. I'm a visiting fellow at Opportunity Solutions Project. a nonpartisan nonprofit that identifies successful program integrity reform solutions across the country. Rhode Island legislators now have an opportunity to address two election concerns: whether persons with advanced age or disabilities are discriminatorily denied the right to vote, and whether citizens' right to vote is diluted by ineligible non-citizens. Today, I am testifying in support of House Bill 6099, introduced by Representatives Morgan, Nardone, and Roberts this March, because it offers real solutions to these concerns. These solutions are to ban ballot harvesting and to require state identification to designate non-citizens. First, the concerns about age and disability discrimination. In September 2020, concerns were expressed that campaign workers targeted elderly residents of the Dominican Manor complex in Providence to get them to pick up their emergency mail ballots for them. This was published in various newspaper articles in Rhode Island. Bad actors in other states have recently been prosecuted for harvesting ballots in nursing homes and group homes for persons with disabilities in states like Texas. House Bill 6099 would make ballot harvesting a crime in Rhode Island. It would deter and punish ballot harvesters who pressure the collection of large numbers of ballots. Criminalizing ballot harvesting would protect the right to vote of the elderly and persons with disabilities, who are a significant percentage of the Rhode Island electorate. This approach, criminalizing ballot harvesting, is far more effective than the approach in other bills before the Rhode Island legislature. For example, House Bill 6003 would extend the time to submit mail ballots and remove the witness requirement. These proposals would only give more time for ballot harvesters to intimidate and take away witnesses' ability to prevent harvesting. Instead, such actions should be a crime, as they would be if House Bill 6009 is passed. Second, for concerns about the dilution of the vote of U.S. citizens. In 2019, a Providence Journal investigation found that 7,000 more people were on the Rhode Island voter rolls than the number of U.S. citizens in Rhode Island, according to the U.S. Census. Non-citizen voting is a problem across the country, as seen in the September 2020 and March 2021 U.S. Department of Justice indictments for non-citizen declarations of citizenship and non-citizen voting in North Carolina. House Bill 6099 would require Rhode Island's driver's licenses to designate if the holder is a foreign national, which would assist in verification of the eligibility to vote when people come to the polls and improve voter roll accuracy. Rhode Island now has an opportunity to adopt the solutions in House Bill 6009. Both of these solutions, criminalizing ballot harvesting and updating driver's licenses, will improve trust and confidence in the administration of elections in Rhode Island. Thank you for the opportunity to testify.
Any questions from members of the committee for Ms. Nerona? Thank you very much for your testimony. Next witness we have is Alabama Secretary of State John Merrill. Welcome, Mr. Secretary. You have 3 minutes to testify on Representative Morgan's bill, House Bill 6099. You have the floor.
Thank you, dear Chairman Shanley, honorable members of the House Committee on State Government and Elections. I'm John Merrill, and I have the privilege to serve as Alabama's 53rd Secretary of State. Since I became the Secretary of State on January the 19th, 2015, we changed the paradigm for voting in the state of Alabama. My team and I have shattered every record in the history of our state for voter registration and voter participation by working with notable Alabamians, local officials, interested leaders all across the state. We have registered more than 1,818,555 new voters since January the 19th of 15. We now have 3,585,688 registered voters. 94% of all eligible African Americans in Alabama are registered to vote. 96% of all eligible African Americans are registered to vote. 91% of all eligible Caucasians are, and 94% of all eligible Alabamians are registered to vote. Subsequently, we've also broken every record in the history of our state for voter participation in the last 7 consecutive elections. This is proof that requiring photo ID to register to vote or cast a ballot does not hinder participation or limit access to the ballot box. We continue to visit all 67 counties in our state every year to issue photo IDs at public events. We will do that are events just designed for this or other public activities. But we will also go to people's homes and give them the free ID if they can't get to one of those locations. By working with members of our legislative body, we've been able to continue to work hard to make it easy to vote and hard to cheat in our state by making sure the electoral process is one that's easy for everyone to participate in. And we would encourage y'all to continue to consider this as an option that will help validate election security and election integrity in your state. When it comes to voter ID, which is IDs are required in so many different areas around the nation, whether it's booking a hotel, purchasing a gun, renting an apartment, buying a home, purchasing alcohol, cigarettes, whatever it happens to be. But we also want to make sure that we are encouraging you to continue to make sure your voter rolls are maintained properly. I did not share with you that we have also actually removed more than 1.3 million people from our voter rolls in that same period of time. So if we can ever be helpful to y'all, we certainly want to make sure that we are. We want to commend Representatives Morgan, Nardone, and Roberts for their efforts on this legislation. I thank you for your time today, and thank you for your work to increase election integrity and election security in Rhode Island.
Mr. Secretary, what strategy did you use to remove ineligible voters from the rolls?
Well, that's a great question. Subsequently, what I usually respond to that question by saying that we removed those people because they moved away from our state, they passed away from this life, or they have been put away. But I think it should be noted that just because you've been incarcerated does not mean that you lose the right to vote. But I will tell you that we follow all the standards that are outlined clearly in the National Voter Registration Act of 1993, and we don't use any other processes that are not a part of that act that was approved by Congress in 1993.
We do have some complaints here, and it hasn't come up as much today, about people that have been registered at the same address for about 20 years, and if they get a piece of mail that's identified as non-returnable, then that happens 2 or 3 times in a row, then they're taken off the voter rolls. But if whoever the current resident is there doesn't return it as undeliverable, then it's not marked as such, and they just keep getting correspondence and they keep staying on the rolls. Do you guys have a different system in place to identify people that are likely moved away, and a fair way to take them off of the voting rolls?
Yes, sir. And one of the things that we're trying to do in this legislative session is actually to pass additional legislation that will enable us to use some other techniques that are currently available through the Postal Service that will enable us to take advantage of things that we can't currently do, that will allow us to follow guidelines that the Postal Service already has in place that puts us in a stronger position to maintain the integrity of the rolls. But we do not create things on our own that will be viewed as being obtrusive or voter suppressive tactics, because we don't think that that's ever appropriate. Of course, our state has not been recognized until the last few years as being a state that's been leading in election integrity.
Thank you. Any questions from members of the committee?
Chairman.
Yes, Representative Morgan.
I can check with the Secretary about what those U.S. Post Office guidelines are and get that back to you.
Oh, that'd be great.
Great.
Any members of the committee have any questions for Secretary Merrill? No further questions. Thank you very much for calling in.
Mr. Chairman, you're very kind to have me as your guest, and anything we can ever do to assist y'all at any level, we'd be honored.
Thank you again. That will conclude testimony on House Bill 6099. Next, we have Chairwoman Williams present via WebEx, and she has a few bills on today's calendar. She has House Bill 5271 and House Bill 5273, both relating to the Medical Marijuana Act. Chairwoman Williams, welcome. You have the floor, and you can take the bills in whatever order you would like.
Okay, I didn't hear you because it seems like the system keeps going in and out, so it might be the weather. But you said 5273 and 5271?
I said it was your pleasure, whatever one you wanted to do first. There's no witness on 5271, so maybe you want to do that one first.
Okay. Thank you, Mr. Chairman and members of the committee. 5271 relates to the transfer of banning license. This bill amends our state medical marijuana law by prohibiting the transfer of any compassion center license to any other owner or location. It would also provide that any new compassion center licenses issued by way of lottery be used only to the location and ownership approved in the application. This bill is necessary to keep our medical marijuana program fair and accessible to all those who invest the time, money, and effort to acquire a compassion center license. It also applies to the potential recreational license as well. These much sought after licenses should not be considered assets that can be bought or sold at this this legislation will ensure the integrity of the system by preventing unauthorized exchanges or sales between a license holder and someone who wishes to bypass the fair and equitable lottery system in acquiring a compassion center license. And that is the testimony for 5271, Mr. Chairman.
Representative Williams, Chair Corvasi has a question for you.
Good afternoon, Chairwoman Williams. How are you today?
Good afternoon. I'm good. And yourself?
Good. I like this bill on the face of it very much. A question. Has this type of situation come up where there's been a transfer? Do you know of any type of incident that has there been any type of incident like this where the license is transferred from the original applicant to someone else?
No, Representative Corvasi, I'm not aware of it, but that does not mean that, you know, this isn't Rhode Island and the games are not played. So rather than waiting till it happens and saying, I wish I coulda, woulda, I'm setting the record or setting everything in play to let them know, no, you're not. Because it's such a one-sided situation right now. It's omitting individuals out of the process, fairly into the process. And one of those ways is, you know, those that are financially able to participate in this lottery to acquire these licenses, you know, some of them don't even live in the state. So there's too much hookup going on that needs to be clearly brought to the surface, and this process needs to be fair. So if you are applying for the lottery, you're applying for the licenses, well, then whichever it is that you're putting down on paper should be legit, and you shouldn't have a problem with making sure that what you say on there, the location is there, and the actual licenses is going to be yours, not that you're doing it for a favor and, you know, keeping the process of skinning the cat 1,900 ways by those privileged few continues. Status quo. I hope I didn't mess you up with my explanation.
I absolutely agree with everything you said. I think that this is a very proactive act, something that I'm surprised we didn't have something like this somewhere in the law already. So I give you a lot of credit for looking forward with this, Chairwoman Williams. I think it's a good bill. My only question, and maybe you've already thought about this, if not, maybe this could be tweaked. What would happen if someone legitimately has the license and then legitimately, for some reason that we are not able to foresee or talk about here, was not able to follow through with the center. Is there some type of mechanism? Is there a mechanism in the law where would the license revert back to the state, or?
No, there's none of that. There's none of those provisions in place, but that's right there.
Maybe
what
you should
just
think of
stated
that.
would be an answer to that. It reverts back into the pool so that others can apply. You lose it, it's no fault of your own maybe, but if you can't proceed with how you may have had planned, then just leave it.
Chairwoman, we
draw
have
it
a
in.
fire drill. We have a fire drill, so the committee's going to be at ease for a minute. And
Okay.
we'll be back as soon as we can.
Okay, it's fine.
Oh, okay.